Business on the daily file, second reading. Clerk will read.
Assembly Bill 2448, 2531, 1639 with amendments, 2048 with amendments, 1905 with amendments, 1958 with amendments, 2458 with amendments, 2498 with amendments, 1887 with amendments, 1645, 2885, 2710. Assembly Constitutional Amendment 6 with amendments, Assembly Bill 1891 with amendments, 2291 with amendments, 1847 with amendments, 2017 with amendments, 1574 with amendments, 1787, 1947 with amendments, 1563, 1579, 1678, 1682, 1684, 1706, 1720, 1744, 1746, 1782, 1784, 1802, 1813, 1824, 1917, 1976, 2080, 2232, 2729 with amendments, 2756 with amendments, 1657 with amendments, and 2566 with amendments.
All bills will be deemed read and amendments deemed adopted. Members, we will now take up SCR 120 Hill without reference to file. The clerk will read.
Senate Concurrent Resolution 120 by Senator Hill relative to biotechnology.
Assemblymember Mullen, you may open on the measure.
Thank you, Madam Speaker and members. SCR 120 declares today as Biotechnology Day in California. As chair of the Select Committee on Biotechnology and representing a district that is the birthplace of the biotech industry, I see firsthand the vital role the biotechnology industry has on my community and California's innovation economy as a whole. According to the 2016 California Life Sciences Industry Report, there are nearly 3,000 life science companies in our state. They directly employ over 280,000 individuals and generate $130 billion in revenue. The majority of those companies reside in Northern California, with several others in the Los Angeles, Orange County, and San Diego regions. It is an honor to recognize April 7th as Biotechnology Day to celebrate all the life sciences companies like manufacturers, device makers, and research institutions in California. These companies push the boundaries in innovation and continue to keep California #1 as the place to do business in the biotechnology arena. I'd like to thank all those members with biotechnology companies in their district who signed on as co-authors. SCR 120 passed the Senate last week on a vote of 35-0, and I respectfully request your aye vote.
Are there any other members who wish to speak on this item? Assemblymember Waldron, you are recognized.
Thank you, Madam Speaker. I too rise in support of SCR 120. Biotechnology has a huge impact on our state. When I've toured the facilities in my region in San Diego, I am amazed at the new innovations and excited about the possibilities of improving health care for our residents throughout the state. Their quality of life will be much improved. Our young people are getting high-paying jobs, and there's a future for our economy as long as we maintain and help our biotechnology companies to thrive here in our state. And I welcome them to our floor, and thank you so much for supporting this resolution.
Assemblymember Riley Thomas, you're recognized.
Thank you, Madam Speaker. I rise in affirmation of our two colleagues from San Mateo County's bill. Colleagues, this is more than symbolism, because the promise of medical innovation, precision medicine, cures, and the like improves quality of life for our constituents. It improves the economic environment and the taxable income, corporate and personal income, and property taxes that come into the state. And it gives individuals the dignity of high-wage employment. So the biotechnology industry, which we see thriving in San Mateo and portions of the Silicon Valley and San Diego, we want to see continue to grow and make it across the state. We hope in Los Angeles County to build 4 biomedical hubs that mirror what we see in San Diego and in the Silicon Valley, and we are extremely excited about what that will bring. Thousands of jobs, thousands of clinical trials for patients to cure some of the most difficult diseases that have faced humanity. So I salute the floor manager, our colleague from San Mateo, and the author from the Senate from San Mateo as well for this important symbol that the state legislature embraces the biotechnology industry, wants to see it thrive and grow, and that we will be partners in finding cures, health care, and further economic prosperity. With that, I would respectfully request an aye vote of SCR 120. Thank you, Madam Speaker.
Assemblymember Chavez, you're recognized.
I also rise in to support SCR 120, and I'd like to highlight two issues for the members of the Assembly. In a few weeks, we're going to be voting on the May revise, and in it, it's going to be talking about community college investment. Community colleges are the fastest pathway in which people can get good paying jobs without a BA or a master's. Tomorrow I'll be touring Maricosta Community College in their bio lab, where they have partnered with all the industries within my district to give good paying jobs to young people. Additionally, one of the biggest issues facing California is energy. In a few weeks, I'll have the honor to be at Genentech, where they'll be opening up a solar megawatt plant providing green energy to their site there and able to provide more jobs at a very cost-efficient method. Ladies and gentlemen, the biotech industry is much more than just biotech. It's the opportunity for the future of people, and they're leading the way in how we can grow industry in a very green way. I stand in support of this SCR.
Assemblymember Thurman, you're recognized.
Thank you, Madam Speaker and members. I wanted to rise and echo the comments of my colleague from San Mateo County and my colleagues who've spoken in support of SCR 120. We all know the importance of biotech in our state. It's been very important in our district in cities like Richmond and Berkeley and Hercules. And we're also planning to welcome a new life science campus for UC Berkeley in the city of Richmond. In addition to the incredible benefits that this will mean for creating life-saving and life-changing drugs in the world, it means a great deal to a city like Richmond that is looking to add and build to its economic prosperity in terms of jobs and training. Some years ago, I've had the chance to work for a great job training program in San Francisco that trained individuals to work in biotech who did not have a lot of formal education. It worked through the Community College of San Francisco, and it gave people a chance to increase their education and earn decent-paying jobs. This is one of the great waves to the future for all Californians, and I urge your support of SCR 120.
Assemblymember Chang, you're recognized.
Members, I rise in strong support of this measure. I am grateful this resolution is before us during the Women and Girls in STEM Week, because obviously biotech plays a huge role in that. Biotech is moving us forward in so many ways, including the battle against cancer, but it also provides $259 billion in economic activity in California, so it's also moving our state forward in that respect. Thank you to the floor manager for bringing us this measure today, and I respectfully ask for an aye vote.
All discussion having ceased, Assemblymember Mullen, you may close.
Just thank my colleagues for their sentiments in support of the resolution, and I ask for an aye vote.
With that, the clerk will open the roll. All those who vote, who desire to vote, all those vote who desire to vote, all those vote who desire to vote. Good. The clerk will close the roll and tally the votes. Ayes 73, noes 0. The resolution is adopted. We will now move back to guest introductions. Assemblymember Mullen, you are recognized for your guest introduction.
Thank you, Madam Speaker and members. In honor of Biotechnology Day, I would like to take a moment to introduce two special guests we have with us this morning. 40 years ago, the biotechnology industry was born in California with the founding of Genentech, the first biotechnology company and headquartered in my hometown of South San Francisco. Genentech employs 12,000 and has facilities in Vacaville and Oceanside. Genentech has created an industry that has helped millions of patients and fundamentally changed the way serious diseases are treated. Since 2010, Ian Clark, Chief Executive Officer of Genentech, has led the company in many accomplishments, including 9 approvals for new medicines and 13 breakthrough therapy designations. Under Mr. Clark's leadership, Genentech has been recognized by Fortune magazine as one of the 100 best companies to work for. Joining Ian Clark is Jim Greenwood, President and CEO of the Biotechnology Industry Organization, or BIO. BIO represents more than 1,200 biotechnology companies, academic institutions, and related organizations across the country. Mr. Greenwood was a prominent member of the U.S. House of Representatives, as well as a member of both the Pennsylvania General Assembly and Senate. He has led BIO since 2005, and once again, BIO will be hosting its international convention this summer in San Francisco. The convention is the premier event for the biotech industry, and 15,000 attendees from around the world are expected. Please welcome Ian Clark and Jim Greenwood to the Assembly floor as I present them with a special resolution in honor of Genentech's anniversary.
Members, we will now move to business on the daily file. File item 43 through 52 pass and retain. File item 53, AB 1854, the clerk will read.
Assembly Bill 1854 by Assemblymember Bloom, an act relating to bail.
Assemblymember Bloom, you may open on the measure.
Thank you, Madam Speaker. Members, I rise to present AB 1854, a straightforward measure that aims to relieve some of the financial burden faced by county prosecutors in litigating bail forfeiture cases. Under existing law, the California Superior Court is required to declare bail as forfeited when a defendant fails to appear in court or fails to fulfill other conditions of bail. Bail forfeiture is frequently followed by a motion to vacate the forfeiture, where the defense counsel or bond surety agent can contest the forfeiture by claiming that the defendant had an excuse for his or her absence. There's a significant amount of time that's involved in opposing these motions, and financially strapped local prosecutors, district attorneys, and county councils bear the costs. Existing law allows for local prosecutors to recover costs out of forfeited bail, but a 2012 case held that Contrary to the common and decades-long practice, the term costs was too vague to assume that it included attorney fees. It was allowed to include other costs, but not attorney fees. So the case held that the recovery of costs does not include attorney fees and left it to the legislature to further refine the law. That's what this bill does. AB 1854 inserts the term attorney fees specifically into the statute to allow local agencies to recover all the costs, just as they did before this case held that that was not to be allowed. It will ensure that local government agencies can recover a significant portion of their costs that would otherwise have been lost, and therefore I respectfully ask for your aye vote. Thank you.
Assemblymember Wagner, you're recognized.
Thank you. Briefly, I'm going to support the bill, but it is not without some issues, or it raises some issues that need to be resolved, which I will throw out for this body to consider in the near future. I have no problem with increasing the times and the circumstances under which frivolous motions are met with an attorney's fees clause. Too often they're not, and they would be discouraged if, in fact, it was possible to recover fees. The problem, though, is that this one is somewhat one-sided. It only works on behalf of the counties, and as the bail agents themselves have correctly said in their opposition, why doesn't it go both ways? Why are they not allowed to recover their attorney's fees? I'd urge this body to look at that in the near future, try to answer that question, because I think it's a fairly good question that does need to be addressed. And while we're at it, let's take a look at increasing the number of times we shift fees for frivolous motions to discourage them, clean up the court systems and the system, and allow for justice to actually be done. So with that, I'm in support of this bill, but I do urge this body to take a look at some of the bigger questions it raises.
All discussion having ceased, Assemblymember Bloom, would you like to close?
Thank you. I ask for your aye vote.
With that, the clerk will open the roll. All those vote who desire to vote. All those vote who desire to vote. All those vote who desire to vote. Aye 67, noes 2, measure passes. File item 54 and 55 pass and retain. File item 56, AB 2012, for the purpose of amendments, the clerk will read.
Assembly Bill 2012 with amendments by Assemblymember Bigelow.
On the amendments, Assemblymember Bigelow, you may open on the amendments.
Thank you, Madam Speaker and members. Assembly Bill 2012 is here for amendments as presented. Encourage an aye vote.
Are there any other members who wish to speak on the item? Seeing and hearing none, Assemblymember Bigelow, you may close.
Encourage an aye vote.
We can take a voice vote on this item. All those in favor say aye. All those opposed say nay. The ayes have it. The amendments are adopted and out and back to print on file. Back to motions and resolutions. Mr. Calderon.
Thank you, Madam Speaker. Pursuant to Assembly Rule 96, I request unanimous consent to re-refer AB 24-3017 from the Labor and Employment Committee to the Business and Professions Committee and then back to the Labor and Employment Committee.
Without objection, the request is granted. File item 57, ACR 146, the clerk will read.
Assembly Concurrent Resolution 146 by Assemblymember Weber and others, relative to commemorating the 85th anniversary of Roberto Alvarez versus Board of Trustees of the Lemon Grove School District.
Dr. Weber, you may open.
Yes, good morning, Madam Speaker and members. I'm here today to present to you ACR 146, a resolution commemorating the 85th anniversary of the Roberto Alvarez versus Board of Trustees of the Lemon Grove School District. We often say that the road to justice and equality is a long road, but it is filled with numbers of steps that get us to the end. The lawsuit in Lemon Grove was one of the many steps toward achieving the goal of Brown versus Board of Education. In the early 20th century, a number of Mexican immigrants came to California, and they settled around the area of Lemon Grove, California. They came for jobs in mining and agriculture. And they settled there and became active members of the Lemon Grove community. When the Depression hit in the 1930s, it brought out sometimes the worst in us, fear and anger regarding the downturn in the economy, and increased anti-immigrant sentiments concerning those who lived in Lemon Grove. By the 1930s, 75 of the 169 students in Lemon Grove Elementary School were children of immigrant descent. But most of them were citizens by this time, whose families had been in this country since the early part of the 1900s. So on January 5th, 1931, acting on the instructions of the school board, the principal of Lemon Grove School District, Mr. Jerome Green, blocked the entrance to the school and admitted all the pupil and asked all the pupil of Mexican descent to not enter the school, and sent them to a building across the street as their, quote, new school. The parents obviously were upset and outraged over the segregation of their children, and therefore had a petition for a writ of mandate that was filed in the San Diego County Superior Court challenging the actions of the Lemon Grove School District in segregating students. Fortunately, the Honorable Claude Chambers, judge of the San Diego County Superior Court, issued a ruling granting the writ of mandate sought by the parents of the excluded students. This eventually led to Judge Chambers' order issued on March 30th, 1931, that deemed the separation of children to be an illegal segregation that had no basis in California law, and he ordered the school district to immediately reinstate the children that had been excluded. The Lemon Grove School District fortunately did not appeal the decision, and the students were immediately readmitted to the school. This was a victory for Lemon Grove, but it really was a victory for all of us about the history of California. This morning, the children of Lemon Grove are watching this session live in their schools, and they should be proud of the Lemon Grove School District that 85 years ago stood up, and the judges that stood up for the children in that community. We can only imagine what would have happened if they had appealed it or if the parents had accepted the segregation that existed. We probably would have set the tone for all of San Diego County to legally separate children from their schools. But they fought back, and they formed a committee called the Lemon Grove Neighbors Committee that basically fought the injustices of Lemon Grove. This small community is a proud community of Lemon Grove, one that has tremendous diversity. In the whole county of San Diego, it has the largest population of African American children. 25% of all the children in Lemon Grove School District are African Americans. People find wonderful homes in Lemon Grove, this small district adjacent to San Diego, that has a diverse school board, that has a diverse city council, it has a diverse planning committee. It is truly a jewel in San Diego, the Lemon Grove School District. And one has to believe that the foundation set in Alvarez versus the Lemon Grove School Board was an example of fighting back and what San Diego stood for. So I'm very proud this morning to honor those who fought for the children of Lemon Grove, to continue to honor the children of Lemon Grove who attend a school district that really is a diverse school district, and respectfully ask for your support of ACR 146 on the 85th anniversary of Alvarez versus the Lemon Grove School District, and request that the first vote be open for co-authors.
Assemblymember Alejo.
Thank you very much, Madam Speaker and members. On this day, I also rise to commemorate the 85th anniversary of this very important landmark case in the history and legal jurisprudence in California, and certainly want to recognize all the children at home who are watching this hearing here today, and I want to thank them for tuning in and learning about this important case in their own communities. We are rightfully aware of the importance of Brown versus Board of Education in 1954 and its rightful place as a turning point for not only civil rights, but in ensuring more equal levels of education for all children in the United States. However, what many do not realize is that Brown was actually a culmination of many earlier cases challenging school segregation and promoting civil rights. We all know the tremendous and powerful story of the General Counsel of the NAACP, Charles Houston, who mentored an entire cadre of young lawyers, people like Thurgood Marshall, to win many precedent cases in the lower courts. And those cases were going to later be used and were the precedent for Brown versus Board of Education in 1954. But early on, the first successful school segregation case was this one, Alvarez versus Lemon Grove, and that was in 1931, 23 years before Brown was ever heard before the U.S. Supreme Court. As the author has already pointed out, Lemon Grove was targeting its Mexican and Mexican-American students for segregated schooling. And this was not just a metaphorical separation. The principal of Lemon Grove Grammar School physically blocked his students of Mexican descent from entering the schoolhouse. Alvarez versus Lemon Grove is a sad reminder that many communities of color, whether black or Latino or Asian or Native American, were subject to the injustice of hateful Jim Crow laws and school segregation, including in our own state. I am particularly proud that the first victory for desegregation movement was secured by parents who were immigrants from Mexico, who took to the courts to demand that their rights of their children be respected by their own government. The parade of these children from Roberto Alvarez in San Diego to Linda Brown in Topeka, Kansas, helped work towards the dream that children in America will no longer be subject to separate and an unequal education. Colleagues, I ask you to join me in supporting this historic legal victory for the children in California.
Dr. Weber, you may close.
Thank you very much. I want to thank my colleague representing the Latino caucus for the support and for all of those who will support this initiative. As I pointed out, this is a landmark decision in San Diego County. And we can only imagine what would have happened if the parents had not fought back the segregation of their children. Lemon Grove School District and the children who are watching us live should be very proud that they stand on the shoulders of some tremendous heroes and heroines who basically fought for their right to have a quality education in California. And I respectfully ask for your aye vote.
With that, the clerk will open the roll for co-authors. There are 69 co-authors on the measure. Now we can take a voice vote on the item. All those in favor say aye. All those opposed say nay. The ayes have it. The resolution is adopted. File item 58, ACR 150. The clerk will read.
Assembly Concurrent Resolution 150 by Assemblymember Atkins and others relative to prevention of cruelty to animals.
Speaker Emeritus Atkins, you may open on the measure.
Thank you, Madam Speaker. I rise to present ACR 150, which commemorates April 10th as the 150th anniversary of the American Society for the Prevention of Cruelty to Animals, better known as the ASPCA. Founded by Henry Bergh in 1866, the ASPCA was the first society established to foster the humane treatment of animals in North America. Within just the first 2 years of its existence, the ASPCA had worked to pass animal protection and began enforcing the first anti-cruelty to animal laws in the United States. By the time of Henry Bergh's death in 1888, 37 out of 38 states had passed similar anti-cruelty laws, including California. Today, the ASPCA is one of the largest humane societies in the world, and the legacy of Henry Bergh lives on as the ASPCA works to prevent animal homelessness and animal cruelty, provide grants for shelters, education activities, and advocacy work. As a proud advocate for animal rights in the Assembly, and as a proud pet parent to Haley and handsome Joey, I'm honored to carry this resolution for the ASPCA and respectfully request that the first roll be open for co-authors and certainly for an aye vote on the resolution. Thank you, Madam Speaker.
Are there any other members who wish to speak on this item? Seeing and hearing none, Speaker Emeritus, you may close. I don't think. With that, the clerk will open the roll for co-authors. All those vote who desire to vote. All those vote who desire to vote. All those vote who desire to vote. There are 62 co-authors on the measure. We can now take a voice vote on the item. All those in favor say aye. All those opposed say nay. The ayes have it. The resolution is adopted. File item 59 and 60 pass and retain. File item 61 AB 2159. The clerk will read.